people, you are welcome to turn your camera on if you would like.
Okay, I'll start video.
Hi, everyone. If you're in a place and would like to turn your camera on, you're welcome to. I'll be pinning the speaker as well as we go, and sometimes it's nice to see our community around us too. So as you're here, feel free to rename yourself if someone else was using your Zoom today, and turn your camera on as you feel comfortable. And we'll get started in just 1 minute from here.
Do you want me to hold it like this?
Okay. So we'll keep letting people in, and I'm going to give the floor, this is Stephanie right now, to know me for a moment. I'm going to stop sharing, and we'll keep letting people come into our space as we begin. So if you would like to put your Zoom in speaker view, I'm going to spotlight Nomi, and she's going to start us off, and then I'll give us a few more Zoom notes after that.
Hi, everyone. Welcome. We are so thrilled that you could join us this evening. My name is Nomi Mitchell. I am the interim JConnect manager for Hillel University of Washington, as well as the Israel Education and Engagement Program Manager at the Jewish Federation of Creators Seattle. With me, as this is a partnership event, with me on the call and monitoring, managing this conversation that we're about to have is Stephanie Aronson, who is the Community Development Manager at the Straum Jewish Community Center. So thank you all so much for joining us this evening. We are thrilled to introduce Dr. Dana Raigrodski, who is going to be leading us in the conversation tonight.
Thank you, Nomi, and thank you both, Stephanie and Nomi, and the SJCC and JConnect and Hillel for facilitating what is clearly a very timely event. And I appreciate the opportunity to share some thoughts with everybody. And thank you, everybody, for showing. Whoops, sorry, that is what happens when my computer goes splat. Thank you, everybody, for showing up. I do want to also just take a moment to thank some of my UW Law colleagues, specifically Professors Liz Porter, who actually clerked for the late Justice, as well as Professors Lisa Mannheim, Peter Nicholas, and Clark Lombardi, all of whom shared really fabulous insights and comments with me ahead of this panel and ahead of this discussion. So hopefully it can inform our conversation today. And I'm going to send it back to Stephanie, I think, for some of our Zoom guidelines.
You see that?
Thank you. Hi, everyone. Thank you so much for joining us this evening. As I noted when you were coming in, we decided to have this in meeting view so that we can all be surrounded by our community. And if you're making dinner or just getting something ready, that's okay to turn your camera off. We are going to ask also that you have your own name in your Zoom. So if you go to the top corner of your own Zoom, rename yourself or put your family name in, whatever makes sense for you. Please feel free to add your pronouns as well. And we're going to start with questions for Dana. We have a few that we're going to be asking. She'll be exploring these topics with us as we look at Justice Ginsburg's legacy, the Supreme Court nomination and confirmation process, along with how the Supreme Court justices view and rule on the Constitution specifically. And from there, we also ask that you post questions as you have them. So we're going to have a dynamic space. We do ask that you put the questions into the chat, and then we will include them as we go along. We may ask you to share your questions, so feel free to unmute. And if you don't want to do that, myself or Nomi can ask the question for you. So if you put it in the chat, we'll make sure to ask the question in the space of the subject that we're in. And if you think of it later, no problem. You can still post it and we'll try to get to everyone's questions. So you can either post your question directly to everyone, or you can send it to me at Stephanie SJCC, and we'll make sure that we get your questions asked as much as possible and keep us on time. So from there, Nomi's going to start us off with our first topic.
Great. Thank you. I would like to say as well, in between the questions that I will be posing for Donna, I will also leave space for Stephanie and you all to ask your questions in between. So we would like to create a conversation in this space. And with that, question number one, can you tell us about some of the highlights of Justice Ginsburg's time on the Supreme Court?
So absolutely, although I would likely do injustice for the late Justice Bader Ginsburg, because her accomplishments were significant, not only on the bench, but in academia before that, and at the ACLU, when she really created their women's advocacy division and started bringing significant gender equity cases in front of the Supreme Court. But before I do that, I do actually want to take a quick step back. I intentionally kept some of my introduction back just to contextualize what the impact of Justice Bader Ginsburg has been on me. And I think it has been on many, both men and women, but maybe more so women in the US and around the world. And I think that ties directly with the role that she played throughout her professional and personal career, and particularly on the Supreme Court for many of us. So I'm a faculty member at the University of Washington Law School. I'm also, though, originally from Israel. So I migrated to the US. I've been here by now quite a while. And before that, I practiced as a prosecutor in the Israeli Defense Forces. So I shifted to academia, but I've always had this passion, right, to litigating, to advancing rights. Most of my scholarship and my teaching these days focuses on feminist jurisprudence, critical race theories, issues of human trafficking, gender-based violence, and gender equity. So for me, right, when I heard Justice Bader Ginsburg talk about the three strikes against her, right? She was Jewish, she was a mother, she was from a working background, that resonated with me, right? Much of my professional career, I was, and nowadays even more so, right, having to deal with work-life balances. So I think specifically for working women and working families, Justice Bader Ginsburg had made a huge impact. So some of her key advocacy on issues of women in the workplace, right? Sexual harassment issues, gender-based discrimination, the Lilly Ledbetter decision, where she strongly dissents from the majority opinion, which basically blocks Ms. Ledbetter, who was a supervisor at Goodyear plant, and was being paid 15% to 40% less than her male counterparts, but she had no way of knowing it because there was no way of seeing the paychecks of other colleagues. And eventually when she finds it out through an anonymous tip and brings the suit, which eventually works itself out to the United States Supreme Court, the Supreme Court says, too bad, too late, the statute of limitation has passed because the employer really started discriminating against you in the late 70s. And Ruth Bader Ginsburg writes and reads from the bench a very, very strong dissent saying that the court is really unrealistic in the way that it does not understand the multiple invidious ways that women are discriminated against in the workplace. She's been a prominent advocate of issues of autonomy and choice, abortion being one area, abortion and contraceptives and family planning, really looking at it as a choice that women should be able to make, and again, allowing women to fully participate. So there are many other cases. I'm probably going to talk a little bit more about some of them later on, but I just wanted to highlight that. And I do want to just add more concretely about her approach, right? The impact that she's left was also in how she approached pursuing justice. It wasn't about radical changes. It wasn't about judges being, all powerful and making the laws all the time. She was a firm believer in moderation, in making incremental changes, in the role of Congress, actually, rather than judges, in making laws and advancing the laws. But often her dissents were trying to plant the seeds for the future, or to basically tell Congress, do your job, which in Lilly Ledbetter they did. That was the first piece of legislation that President Obama signed into law. And actually Justice Bader Ginsburg worked behind the scene to help in shaping that law. So I'll stop there because I'm sure we'll have more opportunities to come back to that. And I see some things pop in the chat already.
Yeah, thank you. Do we have any specific questions from the audience at this particular time in regards to Justice Ginsburg's time on the Supreme Court, or perhaps to discuss some of her more notable decisions or notable impacts on our lives today?
We don't have specific questions. I'm happy to dive into a few more things, but you tell me.
Yeah, I think that this question in the chat will be perfectly aligned with a question 3 probably, so we'll bring it back up then. So Laura, thank you so much for asking. We'll make sure to bring it up in a moment, and if you want to continue with a few other notable pieces, that would be great.
So I would, so I started by saying that the impact has really gone beyond just the United States, right? And I'm not just talking about, I guess, the pop culture mythology and the notorious RBG, right? And all the fame and admiration across generations. But actually, on September 18th, right, on the day, the evening when Justice Bader Ginsburg passed on New Year's, on Erev Rosh Hashanah, I was actually concluding an early fall start program that I teach to law students at the University of Washington, many of whom are legal professionals that didn't grow up in the US and were trained outside of the US, or some that are not lawyers and are now pursuing other studies at UW. And the news broke and we were all devastated. And we spent the rest of our time talking about individual rights, but also about the impact of Ruth Bader Ginsburg. And it was so moving for me to see how many of my students, many of them are migrants to the United States, many of them are mothers, really talking about how inspirational she has been to them. Again, I think for working women, for people who are managing too many things, right? Think about some of the early cases she brought. These were cases brought on behalf of men that were maybe filling non-traditional gender roles, like caretaking roles. She viewed equity as something that applies to everybody, right? She fought for dignity and equity for everybody. So sexism impacts men and women, right? Racism impacts everybody. So in that sense, she was advancing to break down some of those silos and some of those isms that we have in society, specifically sexism and gender-based issues. But she wasn't necessarily only advocating for women. And I think that's really some of her greatness. So when she was deciding the Virginia Military Institute, the VMI case, which was one of her key early decisions, striking down right, elite military school not allowing women to be admitted, it was not just because women were being disadvantaged by that, but it was because society as a whole was lacking when women and others were not being, I guess, given full opportunity to present and share their talents. So I think that speaks to a lot of the things that we are seeing today.
Thank you. Moving on to the next question. we're going to zoom out a little bit right now to talk about the Supreme Court and what are some of the decisions that the Supreme Court is making on a regular basis that is impacting American lives. Why should we care about the Supreme Court, especially right now? If you could talk a little bit about that and kind of zoom it out for us.
Well, I don't know that if anybody who's tracking any news here or around the world, I need to actually answer that question. It seems to be pretty obvious these days. But the fact is that, particularly in the United States, right, because the Constitution sets up both the structure of government and the relationship between the branches of government, right, the legislator, the executive branch, and this is not a civics class, I'm giving heads up to everybody, right, but because the Constitution sets up both the structures of government and the relationship between the branches of government, the relationship between the federal government and the states, and of course, protections of individual rights, it plays a key role in many aspects of our lives. So some of the more obvious areas, whether it's, you know, the issues that have to do with equality and equity, whether it's services or, you know, workplace discrimination to LGBTQ, right? The Bostock decision that just came down and talks about that, same-sex marriage, reproductive rights, right? Abortion, contraceptives, right to life, right to die with dignity, but many other decisions, voting rights, crucial area where the court has had to jump in because laws, even when we do have them, tend to require interpretation. The Constitution requires interpretation. So the way our system is structured, the court plays a key role in being, in a sense, the ultimate arbiter. Now, it hasn't necessarily always been the case. The court at some point took that role upon itself in Marbury versus Madison, but that role hasn't really been questioned. So when we have those, I guess, both institutional battles or federalism battles or issues of the scope of individual rights, it is the court that steps in to fill that gap and to provide that interpretation. Obviously, I suspect everybody is aware that the Affordable Health Care Act and the scope and the legitimacy, I guess, of the ACA is something that the court is going to look at. Issues of immigration law, businesses, right? Privacy rights, criminal justice issue. Many of those issues end up percolating and getting up to the United States Supreme Court. So I would say that there's probably no aspect of our day-to-day lives in a complex society that is not in one way or another shaped by decisions of the court. Now, it wouldn't necessarily always be the Supreme Court. Much of it is shaped by state courts and lower federal courts, which is a whole other issue we can talk about. But, you know, some of the key issues do get up to the United States Supreme Court. So it is important to pay attention.
Thank you. I do want to pause and allow for questions if there are any questions from the audience at this time.
I think Laura's question is perfect for this moment. So Laura, if you want to unmute and ask your question, you're welcome to.
Okay. I asked two, so which one is the one that you think is perfect for this moment?
I think the one you most recently asked. I'm trying to find you.
Okay. I said, in our current culture of polarization, I'm interested in RBG's approach on, quote, mediating, respect for dialogue on both sides of the aisle. How did she accomplish and sustain this?
I think, right, so I mean, there's a lot that's been, thank you, this is a really good question, Laura, I appreciate it. There's much that's been said, obviously, about the friendship between Justice Bader Ginsburg and Justice Scalia, for example, right? Clearly they were on different sides of the aisle, but they respected each other for their judicial candor, I guess, and judicial philosophy. So even though they often did not agree on the substance, right, they knew that each one was coming from a deep conviction about the rule of law, the place of judges in society, and basic democratic principles, because there is some issue with a court that is not a democratic, accountable institution, right? Making these big decisions. So I think both, for example, were restraining themselves. So as I've mentioned, Justice Bader Ginsburg wasn't about to push radical changes necessarily, right? It was really trying to gauge what society is ready for and what would the people, right? It's we the people that the court serves. And same thing with Justice Scalia, even though clearly I personally wouldn't have agreed with him on many decisions, I could see how he was structuring those from his perspective to respect precedent, to try and faithfully interpret the law, to try and faithfully not encroach on maybe the other branches of government. And generally, I actually think most of our judges do that. So I can see why someone who is nominated to be on the Supreme Court would get very upset when they're asked a question about kind of predetermining their mind about an issue. I do actually trust that the judges try. Now, I think there are some caveats to that, but the partisanship that we're seeing in the political universe and in our public discourse generally is very problematic because everybody seems to be taking everything so personally and everybody seems to be retreating to their own corners, right? I used to be a prosecutor. I would duke it out with the defense attorneys in the court, but then we were each representing our clients, doing our jobs, and then we would go out and then do other stuff. This is something that has nothing to do with the justices, but I think most judges, and particularly Ruth Bader Ginsburg, I see it with other judges. Look at Justice Roberts. He's definitely taking much more of a collaborative approach. That's how I think generally we should be, but clearly not everybody would think that.
Thank you. I want to take one moment because a few people have come in late to first of all welcome anyone who came in. I hope everyone's had a great day. And if you put your Zoom into speaker view, we'll be pinning the person who's speaking. And again, if you have questions, you're welcome to post them in the chat or send them directly to me. The name is Stephanie, SJCC. And we will make sure that we have a moment for those. And speaking of questions from everyone who's here, there are two questions on court packing. So I think after speaking about how Justice Ginsburg felt about mediating and the respect for dialogue, it does make sense to if we can ask what exactly is court packing so that we're all speaking from a place of understanding. And then one of the questions is about whether Justice Ginsburg had any knowledge, had a view on the matter of packing the court. And Laura also had a note, I'm trying to pull these together. So what is court packing? Did Justice Ginsburg have an opinion on what this looks like? And we'll start there. And Laura, if we haven't grabbed your other question, you can jump in and ask the rest of it.
Thank you.
So I'll start with reverse order. So I do not know if Justice Bader Ginsburg had an opinion on court packing. It doesn't mean that she didn't have one. I simply don't happen to know it. If anybody in the audience happens to know, please feel free to share it with us. But generally speaking, right, so right now we are very accustomed to just having 9 justices on the United States Supreme Court. That is not a given. There's nothing in the Constitution or even there's nothing that says that the Supreme Court has to only have 9 justices. During FDR, we actually were in a situation that the executive branch was passing significant, very progressive legislation, minimum wage, maximum work hours, right? This is on the heels of the Great Depression. We have a very progressive legislator and executive, and the court is actually the conservative one. And they're basically striking down. They are basically rejecting, saying that those pieces of legislation violate the Constitution. I'm not going to jump into how, right? But basically, the president is not particularly happy with the court and threatens to increase the number of justices. So basically, dilute the vote, right? So let's say taking it from 9 justices, maybe they were a 6-3 split. right? Adding 5 more justices or 7 more justices, right? Which the president with the then favorable Senate, right? Same party would appoint, potentially will just make sure that you're shifting the balance within that court. That actually backfired. So that situation, the standoff between FDR and the Supreme Court actually ended up with the Supreme Court backing down. So they stopped striking down some of that progressive legislation, and FDR never really executed the threat to pack the court. But politically, this actually backfired. From what I know of US history, this wasn't a very good move for FDR. So that's where they are, right? You're hearing those discussions about, should we just increase, right? Assuming that if we do have, let's say, a Democratic president with a Democratic Senate, they can say, let's make the Supreme Court 13 justices and let's just appoint, 4 more justices that will all be Democratic, and we can rebalance the court. So that's what court packing means, just increasing the number of justices on the United States Supreme Court.
What I was wondering about is, isn't it true that court packing, if it does happen, requires Congress, and it can't just be done by executive order? Correct me if I'm wrong. And
Correct.
And if that is true, then why is that not being talked about when Joe Biden and Kamala Harris are being asked to answer the question? And why can't they just say, well, we couldn't do that by ourselves? What's your opinion on that?
So maybe I should have started this presentation by saying, obviously, every opinion that I'm expressing here is mine and mine only, right? This is not representative of anybody. To be honest, I don't see a reason to play that card right now. I think this is just a conversation that would be a distraction from so many other things, and probably a conversation that can cause more people on both sides of the aisle to retrench in their positions and go back to the corners. So I think they probably could have given some better answers, but I just don't think that this is a conversation that's worthwhile engaging with right now. Strategically, why do you want to show your cards? I don't happen to think it's likely to be the most successful card, but I just don't see why they need to discuss it in any event. But again, this is my own personal opinion. I know that there were a lot of other things that Nomi and Stephanie wanted to get to. So if we have time towards the end to go back to this or tie it with the confirmation hearing, I'm happy to talk more about that. But I think people have different opinions of this. Oh, and thank you, Terry, for enlightening all of us that she was against court packing in her earlier interview from this year. Thank you, I appreciate it.
Thank you all for your questions and insights into this conversation. This question kind of falls nicely with the conversation we were just having. Can you walk us through what the nomination and confirmation process for a Supreme Court justice looks like? And we're kind of experiencing it and living it in real time with the nomination for Amy Coney Barrett, and seeing what questions are being asked of her right now, and was wondering if you could speak about that for a little bit.
So I will say that this is actually a nomination process that applies to any federal judicial position. And other positions that are not judicial positions. So this is not limited to the United States Supreme Court, although clearly we tend to pay more attention because this is 1 out of 9, at least for now. And that actually, so under the Constitution, I've mentioned earlier that the Constitution sets up the structures of government, separation of powers between the 3 branches of government, and at the same time creates what we call checks and balances. Again, this is not the constitutional law class, which means that each branch of government has the ability to monitor, right, check and balance the other branch of government. One of the things that our founding fathers and through the Declaration of Independence, we really, really wanted to avoid was concentration of power like we saw under the British King, right? So we divided the power and then we gave each branch of government the ability to check and be a little bit of a stoppage to some of the other actions of government. So the nomination process is an example of a check and balance. So you have the nominee being nominated by the head of the executive branch, i.e. the president, but the actual confirmation needs to happen with the advice and consent of the Senate. So actually not the entire legislative branch, which is part of what we're seeing right now, but just the upper chamber, just the Senate, which theoretically was set up to represent state interest rather than maybe the interest of the populace. So when you do have a Senate and a president that are from the same party, then maybe it's less of a check. It was never intended to be, how shall I put it, a rubber stamp process. And I think what is maybe troubling to many within the legal environment, right? And this has nothing to do with, with me agreeing or not agreeing with who the nominee is, right? Again, judge, well, soon to be Justice Coney Barrett, right? If it proceeds the way it proceeds, right? Holds very specific ideological or, you know, potentially political, we don't know, position. She's being nominated by a Republican by name president to be confirmed by a Republican controlled Senate. That's fair. That's how the system is set up. I think what maybe is troubling, and we've seen that before. I mean, we've had other situations where you've had very tight confirmations when you had a very split Senate. Now, I will note that Justice Bader Ginsburg, who was clearly appointed by President Clinton, was voted in with 93 votes on the Senate. And most justices, at least until recent years, tended to be less partisan. So even though they were viewed as maybe representing liberal democratic views or more conservative views, there was still the sense that if they are good judges or, you know, very smart and compassionate people, and we trust their discretion, their judicial discretion, I guess, that they deserve the seat on the bench. It's become a power play, right? So when President Trump noted that the former President Obama left him with over 120 empty judicial positions, he neglected to mention that the Senate, which was controlled by the Republicans, basically blocked each and every one of those, right? So it's not like President Obama didn't want to fill those positions. So all we need is the president to nominate and the Senate to give their advice and consent. Historically, it hasn't been a rubber stamp process. Not to say that it's always collegial, but I think there was more focus maybe on the merit of the nominees. And I'm not saying Coney Barrett is not meritorious. I actually think she meets the criteria, I guess, like many other nominees that we had. But it is what it is, right? It is a political process for a position that we would want to not be political. And that's not the case in every other country around the world. So this is actually something that when I came here, was really weird for me to see this very politicized judicial nomination process. That was a long answer for a short question.
I want to thank you. I want to pause here to see if there are any questions from the audience that want to be asked in regards to Supreme Court nominations or anything.
We do have a question that ties perfectly into our next topic, so I'm going to hold on to it until then and still open the floor. If someone does have questions, feel free to unmute or post in the chat in the next couple moments.
I would like to ask a question.
Yes.
This is Louise Angel Kiss. I'd like to ask if the time frame in which this is being done, and I don't mean that the election is taking place, but the rapid fire that it's taking place. I mean, it's like in 2 weeks' time, they're going to be voting on yes or no for her. Obviously, it'll be a yes because the Senate is Republican. But is this not unusual to have it done so quickly?
I will, thank you, Louise. That is an excellent question as well. I think, so typically what really takes a long time is not necessarily the confirmation process itself, is actually, is more the initial vetting and the shortlist process still on the executive side. So when the president wants to nominate someone, right, there has to be very, very extensive vetting for any federal judge. So again, not just the Supreme Court justices. So that means really digging up everything and anything that they've done throughout their lives, talking to all their friends, acquaintances, employees. So it's actually typically the vetting process that takes a long time. In this case, if you recall, Judge Connie Barrett was originally, I mean, she's only been on the bench for 2 years. I think she was actually confirmed on October 30th or something like that, 2017, right? So in fact, most of the vetting, right, presumably, unless she really misbehaved in the last 2 years, there wouldn't have been any skeletons that they wouldn't have found out already in 2017. And again, she went through the confirmation process in 2017. It was basically the same people, right? So I think that's what enabled some of this process to move quicker. And of course, political will to move it quicker. When the political will, like we had with Judge Garland, was to not even provide a hearing, there are procedural moves on the floor of the Senate that can prevent that. So I think it's a combination, it's a confluence of several factors. But she was previously vetted, and there really hasn't been much to view in her judicial record over the last 2 years that would significantly slow it down or change it.
But they've just recently come up with new papers or speeches or things that she signed her name to, that they've just discovered just in the last day or two. Isn't that kind of significant that these were not presented by her, nor were they brought up at the time that she was confirmed earlier in 2017? So here is my personal view on this. So I laud definitely, whether it's public watchdogs or media or democratic representative, to try and do the vetting as much as possible. And if it means finding stuff that wasn't previously disclosed, yes, it's important to bring it up. At the same time, it's not like her opinions on abortions are unknown, right? It's not like her affiliations on those issues are unknown. And to be honest, I'm just thinking, as a professor, sometimes you end up giving lunchtime presentations to a lot of student organizations. So I don't necessarily know that the fact that it didn't make it on the paperwork suggests that she was being less than forthcoming in trying to hide it. If she has been, yes, I think that's a challenge. And clearly that's what some of the argument is. I don't know whether that's necessarily the case. And again, unfortunately, we've seen the political power work in mysterious ways. I mean, to me, I'm thinking about what I personally viewed as very traumatic confirmation hearings for now Justice Kavanaugh, right? And things that came up there and whether they were given due course to investigate or not. So here, I don't know whether she did or didn't intentionally try to hide stuff, but to be honest, all of that stuff is pretty much known. So I think it's laudable that they're trying to use it to slow things down, but to be honest, I think this is a fait accompli. I'm not trying to depress anybody, but this is a fait accompli.
And before we move on to our next topic, Sally's question is also right in this sphere of space about year limits. Sally, do you want to ask it, or would you prefer I do?
Sure, I can ask it. I've heard talk about 18-year term limits on Supreme Court justices, and I don't know who's proposing that or what, but is that something that happens in other countries, or do other countries also have lifetime appointments like we do?
I'm not going to speak for all countries. Most countries that I'm familiar with that have had kind of a high court of justice, like we have in Israel, for example, or some form of a constitutional court or a Supreme Court, do try to align it with life tenure. And I mean, and the philosophy behind it is a valid one, right? The idea is that if you provide life tenure, like professors, I guess, you free them up to really rule freely without being subject to political pressures. At the same time, there is clearly a democratic deficit with this type of a structure, right? There's a lack of an inherent lack of accountability. Most systems tend to think that it is worthwhile, right? Same thing why the Constitution fixed the salaries of judges. It's to shelter them from outside influences. I wouldn't be able to say if most countries put a time limit on judges or not without doing more of a deep of a comparative research, but more of the countries that I'm familiar with do proceed with a life tenure.
Okay, thank you.
Not to say that it's maybe a good idea to create a term limit, but that hasn't really been the custom.
Thank you. And before we move on to that last topic, I do want to note that in a moment, I'm going to repaste all of our announcements. There's a few other experiences that we wanted to share with all of you that we thought might be of interest. So I'm going to post them in a moment in the chat. So before you leave, feel free to copy and paste or click on links to open it in your browser and take a moment to see those. And again, we're going to move on to our last topic in just a moment. I also wanted to take a note to just say thank you and see all of our community around us. This is an amazing turnout. And with that, I'll give it back to Nomi for our last question, or last topic.
Thank you. So previously you had noted that justices view the Constitution differently based on interpretation of the law and understanding that the Constitution is a living document, or some see it as a living document versus a traditional document. Can you tell us more about that and how it can help us determine the ways in which justices vote? For example, Justice Scalia and Amy Coney Barrett are understood to be originalists of the Constitution, interpreting the Constitution in its original form, and how that might influence how they vote versus other justices on the bench.
Okay, so I'm going to try and think about how to answer this in a way that will be nuanced enough. So I would actually, in a sense, caution anybody from thinking that we can ever really predict how a judge or a justice would vote. Maybe I'm naive, maybe I still believe in the fact that judges do want to kind of follow the broader legal framework. But that actually does tie with one, how judges view their role as a judge, and specifically to your question, how that also influenced their approach to specifically statutory interpretation and constitutional interpretation. So typically we talk about judges that are maybe viewing themselves or being characterized more as active judges, and then judges that are being characterized, because I don't think any judge actually views themselves as being an active judge, right? But being characterized as being less active. And when we talk about judicial activism, we typically talk about judges that are perceived as feeling more free to maybe interpret it so in our system and in many other systems, the main role of lawmaking lies with the legislator, right? So lies with Congress, for example, or with the state legislator. And in theory, it's not the role of the courts to replace the legislator. The courts are not supposed to rewrite the laws. So the claim is the judges that are activists more freely put themselves in the shoes of the legislator and really replace what the legislator said, whereas judges that are not activists will not do that and will be more deferential for the legislator. As happens to be the case, Ruth Bader Ginsburg, right, and Scalia were very similar in that respect. Ruth Bader Ginsburg actually was much more deferential to Congress than I think many would think. And in fact, in her dissent in Lilly Ledbetter, she basically concludes by saying, Congress, the ball is in your court. You now need to fix what this court did wrong, right? And you need to clarify that the intent behind Title VII, behind workplace discrimination laws, was to create the pathway and not to put all these barriers on, let's say, women who want to be to sue their employer on workplace discrimination. So she said, Congress, you do your job now. Same thing with Shelby County, a really important voting rights decision from 2013, where again, basically the court says, well, you know, the Civil Rights Act, so there was a provision in the Civil Rights Act that for states who had a pretty, shall we say, problematic history of trying to disenfranchise and limit the vote, they needed to get a pre-clearance before they can change their voting rules. We come to 2013, the court says, you know what? We don't need it anymore. Look, everything is working great. We have access to vote. We don't need it. And they basically now don't require the Texas and the Alabamas and, you know, those other states to get that pre-clearance. What do you think happened since 2013? We're seeing it all around, right? So Justice Bader Ginsburg basically tells the court, this is not what Congress intended. You are throwing out something that's working, right? It's like throwing out your umbrella on a rainy day just because you're not getting wet. Her words, not mine. So she sends it back to Congress to try and fix it. So when we come to interpreting the Constitution, generally we talk about those who are originalist, right? They're looking to interpret the Constitution, let's say individual rights or federal-state relationships, according to the perceived original intent of the founding fathers, right? So those who wrote the Constitution and those who wrote the Bill of Rights, circa, right, several hundred years ago, we're going to look at what they meant, what they wanted to accomplish. And often we look at the Federalist documents and some other historical documents. So Justice Thomas, for example, is an originalist. You also have justices or interpretation modes that are textually saying we're just going to interpret the Constitution according to the plain meaning of the words, right? But often it ties with originalism, right? So we look at what words meant in 1789, right? Or later on when we had the 14th Amendment ratified after the Civil War. So Scalia, right, was a textualist. And then you have those who are believe that the Constitution is kind of a growth mindset. The Constitution is a living document. The interpretation of the Constitution needs to move with the times, right? It needs to evolve with the times, which means that, yes, I suspect the founding fathers didn't think about drones, didn't think about same-sex marriage, didn't think maybe about women's equality. And yet, clearly society today is in a different place and we need to interpret the Constitution accordingly. And I think that is probably the key, I guess, concern that many people have with the very likely confirmation of Amy Coney Barrett to the Supreme Court. So it's not only that it's shifting the balance to a very firm, presumably conservative approach, but it's conservative not just in its the political views, but it's also in how it's approaching interpreting the Constitution. And here is something that I think, even though Judge Coney Barrett really, presenting herself as kind of a Scalia-like, there is a particular aspect, so originalist and textualist, there is a particular aspect that I think, and this is where I consulted with some of my colleagues, she does differ based on her scholarly writing. We don't have much of a judicial docket. She's only been on the bench for 2 years. And clearly the confirmation hearings were the same political dance of non-answers that we expected. Unlike Scalia, who was, as a judge, very respectful of long-established precedent. So even if he didn't agree with the precedent, with the decision on the merits, if it was a long-established precedent, he went along with it more often than not. He may have tried to chip on the edges, but he would respect precedent. Based on some of her scholarship and some of her approach for statutory and textual interpretation, it seems that Judge Amy Coney Barrett may be more willing to renegotiate precedent. And I think that's what's concerning for most people. Now, to be honest, the court is not going to change anything, not likely to change anything in a radical manner. I think they're not likely to just wake up one day if they have a suitable case and say, okay, Roe v. Wade is gone, right? This is not Dred Scott. This is not cases that are viewed as being so absolutely wrong that, you know, Bowers v. Hardwick, which criminalized homosexual, which affirmed state legislation criminalizing homosexualized relationship. When we get later on to Lawrence v. Texas, the court says Bowers v. Hardwick was wrong when it was decided and it was wrong today, and they throw it out. But on a case like Roe, I don't think the court will be able to say that. What they will be able to do, though, is to continue biting on it on the edges until eventually they leave it like an empty shell. So I think the approach to how we view precedent, how we interpret the Constitution, is it a living document or do we look back, right? And this is last point, and then I'll stop. The Obergefell decision, right? The one that legalized same-sex marriage in 2015. So this is not one that Justice Bader Ginsburg wrote a separate opinion, right? She was obviously part of the majority, but it's Justice Kennedy who wrote the opinion. But her questions during oral argument and a lot of the presumably behind the scene discussions amongst the justices suggested she was instrumental, right, in reminding some of the other justices, which again were more originalist or more concerned that the Constitution never envisioned it, to remind them that marriage between men and women were structured as a relationship of ownership and mastery. And clearly we don't view that this way anymore. So she was incremental, she was more of a moderate, but I think she was definitely willing to view the Constitution as a living document. And I think the justice that we are likely to get on the Supreme Court may not be assigning to the same philosophy.
Thank you so much for those answers. I know this is something that's of great interest to myself and Nomi, and that was the nugget after some of our conversations that we kept coming back to over and over, and we were very excited for this answer here. I want to make sure, Diana, that this also answered your question in full and see if you had another part that was unanswered. Okay, so if that's the case, please put it in the chat. I also wanted to note that Rabbi Josh said that this debate is also very much alive and well in the context of halakha, which is very interesting. And how are we interpreting the laws in the Torah? How are we interpreting our Judaism? So there are many other conversations going on that are relevant and very interesting to see, I think, for ourselves. I'm curious now to go on and think, how do I interpret the Constitution and what I expect of the Supreme Court, and how do I interpret the Jewish laws that I'm following and what I expect there, and is there any crossover or differences? So that's something I'm going to be leaving with. And there's one other question from Louise. So Louise, do you want to unmute and share your question with us as well?
You can read it.
Oh, great. So who decides if a justice should recuse themselves, and how often does this happen?
Oh, you guys came well prepared. It doesn't happen often. It would happen mostly if, it takes cases a long time to percolate through the system, right? So they don't get to go to the Supreme Court just off the bat. So they have to start, whether it's in a lower federal court or they start in the state courts and then work themselves up. And eventually the party, someone would petition for a writ of certiorari. The Supreme Court gets thousands of petitions every year. They only take a very small numbers of cases to hear. So it takes time. So sometimes it could be the case. So let's say if a case that Judge Coney Barrett, for example, or Judge Kavanaugh, for example, heard while they were on the circuit court, ends up making it up on appeal to the Supreme Court, that would be a clear situation when they should recuse themselves, right? But all the other situation that we're seeing right now, I'm not aware I would assume that the Chief Justice can nudge them gently, but I'm not aware, and you have the canon of judicial ethics, but it's not, there's no black and white answer there. So the black and white situation, like you've related to someone, or it's a case that you heard before and things like that, those are easy cases. They don't happen that often to my knowledge. The situations that we are debating right now, it's a little bit of an uncharted territory. So not a very helpful answer, I suspect, but look, the justices, one of the things that is important for the court to maintain, right? The court really only has its reputation. Congress controls the purse, right? The executive controls the appointment, and it's the public trust that the court really needs to rely on. And that was part of the critique after Bush v. Gore. Again, another great dissent from Justice Ginsburg was she literally just says, I dissent, not even I respectfully dissent. They were so upset. The court has to maintain the public trust. So justice needs to be seen, not only done, right? So I think if there seems to be a lot of backlash, the other justices may all congregate and say, okay, maybe it's better if you don't participate. But to be honest, I don't see that happening. Not in the situations we're discussing, and not too often. And I wouldn't want to assume that any of the justices have made up their mind about anything, for that matter. I hope.
Thank you. Rabbi Josh, I do see that you've put some comments in the chat, and was wondering if you wanted to ask something specific or share your own thoughts.
Oh, no, I'm very happy just to hear this, and just by way of side comments, just highlighting that there are some very interesting parallels. I mean, exactly these same conversations about originalism versus constructivism came up in my halakha classes in rabbinical school, and even today I saw on social media discussions about that in a Jewish context, paralleling the Supreme Court context. So it's all, there's a lot of crossover and a lot of parallel going on, just to let folks know that if this intrigues you in this sphere, it might also intrigue you in the Jewish sphere as well. But really enjoying this. Kol hakavod to everyone who helped put it together. And thank you to Dana especially.
Thank you. Do we have any, because we are coming up on the hour, it's almost 6:30, and we want to be respectful of people's time, but if there are any final questions or comments, please share, either in the chat.
That have come in, so I'm going to take a moment, and I want to mirror and reiterate what Nomi said. We're a minute before 6:30, so if you have to go, we understand, and we will be here for another few minutes to try to make sure we leave with most of our questions answered. So Laura, I saw that you had a question. I saw someone had their hand up, and yeah, so Laura, do you want to unmute and ask your question if you're still here?
I was just wondering how the makeup of the court influences what cases are heard, and how is this decided when, as you were talking earlier,
So
that big group of cases?
So it's not so much the makeup of the court. It is, without going maybe too much into nuts and bolts, right? So the Chief Justice has the same vote like everybody else. So a lot of people wonder, what's the role of the Chief Justice? The Chief Justice does have a role in designating who gets to look at those, right, at any given time in the petition, right? And then what would be kind of the decision-making on whether to grant or deny a writ of certiorari, right? That's the name of the petition that parties submit to the Supreme Court. So there can be, right, minor, maybe not minor, there can be changes there depending on who is the judge or who are the justices that end up looking at that writ petition. I think more times you see the difference between who gets to assign to actually write the opinion, things like that. But the makeup of the court as a whole shouldn't. I don't know if in real life, right? I'm a very realistic person. But in generally, I don't think it should make a huge difference. typically when the Supreme Court decides to take cases, it's because it's a novel issue that really presents an open-ended question and hasn't really been decided before, or maybe challenges a previously decided decision. Or when we have situations where the lower courts have decided differently, we call it a split between the circuits. So the court structure is such that the Federal Appeals Court in New York and the Federal Appeals Court in California can decide different things on the same question, and that's perfectly fine. But clearly that's not very good for the certainty and predictability of the law. So these types of questions often will go to the Supreme Court. But I don't know that the makeup of the court would necessarily have such a direct impact. On that, though, I would probably need to ask a truly constitutional expert. That the procedural stuff in the Supreme Court is not something that I look at closely. But it's a great question.
Thank you. And Terry, I see you're the one with your hand up. Do you want to go ahead and ask your question as well?
Hi. Well, basically two questions. One of them is a comment in a way. Republican senators in the last few weeks, a lot of them are changing their tune regarding their position regarding their, you know who, as Whoopi Goldberg, you know who. So do you think that there could be a change, Dana? Do you think there could be a change in the amount of senators voting against her confirmation?
My short answer is probably no.
Mm-hmm.
And I say that not because I'm necessarily alluding to the fact that all of the Republican senators are, necessarily biased in that way, but I'm just looking at the fact she was confirmed in 2017. Granted, it wasn't for the Supreme Court, it was the Circuit Court, but it was pretty known that she was shortlisted very early on, in the last round. She was already thrown out as being a potential nominee for the Supreme Court. So you can look at their voting records from 2017.
Okay.
Actually, at the time, I think there was one Democratic senator that I guess crossed sides. I don't view it as crossing sides because I would hope that this would be on merit. And here's part of the challenge. And it's actually Justice Sotomayor. So if you look at this nominee, putting aside everything else that's being put on her and how she's being boxed, and I'm not sure that the president is doing her any favors or that Mitch McConnell is doing her any favors, right? If you look at her on her own, and again, personally, I don't agree with many of her positions, but if I'm examining her compared to some other nominees, she seems to be perfectly fine. And in a sense, if you look at, and this is actually Justice Sotomayor that made those comments, it's really important to have justices with different perspective and different experiences on the court, right? So the fact that she is a mother of, younger children, right? That she has adopted children, that she has children who are people of color, that she's coming from a background that's not necessarily as elitistic as some of the other justices, right? That her education is not necessarily in those same 3 or 4 top schools. That's not necessarily a bad thing, right? Whether or not that influences the decision-making by any of the senators that get to vote, I'm not sure. But I doubt it that at this point they will switch, because this will keep them with a cemented legacy for at least 30 years. That and the multitude of federal judges that were appointed for the lower courts. So my answer is probably no.
Okay, and that being said, who is the current oldest Supreme Court justice right now? Is it Clarence Thomas?
No, I don't think so. Okay, I will need help on that one because I cannot Google fast enough. I simply don't remember.
No.
Let me think.
Because what's the chance?
It's not Thomas. I don't think it's Thomas.
Yes, that's what Google says. It's called.
We're talking about seniority in age or how many years they've been on the bench?
Oh, they are. How old? Chronologically, age-wise.
I'm not sure. Who is it, Stephanie?
Oh, this is telling me the oldest person ever to
Oh.
serve. So that's not answering our question. We're current.
Okay, Breyer maybe, right? I don't know.
Okay.
Oh,
I think
I'm not sure.
The reason I asked is I was just wondering, you know, what would be the chances of getting in another Supreme Court justice? Hopefully Biden will win, and you know, once Barrett is probably in, what would the chances of being, you know, putting in another SCOTUS in the next 4 years?
I don't know, your guess is as good as mine. Some of them stay on for a very long time, some of them pass while in office, and some of them just get tired and want to go home. So I don't know.
Okay, thank you.
It looks like Rabbi Josh is correct.
Okay.
Yes.
What did he say?
Oh, sorry.
Justice Brian.
Yes.
Yeah.
At 81.
Oh, okay.
Maybe 82. Great.
Thank you
Says
all
82.
so much. Thank you all so much for joining us and for bringing thoughtful questions and comments. We are so grateful that you came to this discussion this evening, and thank you, a special thank you to Donna for joining us, for leading this discussion and answering our questions. We're really, really happy that you could make it, and please look out for any other emails. And thank you to Stephanie. Look out for emails either from SJCC or from JConnect Seattle. We would love to keep seeing you, keep having you for events in the future. But really, thank you so much,
everybody, and thank you for your great questions. This was really a good discussion, and I'm glad that people, I mean, I'm not surprised. I'm glad that so many people are interested, and maybe I'll see you in some other opportunities.
Thank you, everyone. Good night.
A reminder to vote. Please vote. Vote early. Vote often. If you've gotten your ballot in the mail, fill it out and get it back in the mail.
I'm going to end it. Thank you all so much. Have a great one.
Take care.